Have you ever felt like you're fighting a losing battle against a mountain of rules? Today, we're diving deep into a real-life showdown between a homeowner and his HOA. It's a story that's got everything: a broken wall, documents under lock and key, and a fight for just some basic accountability that, believe it or not, went all the way to a legal hearing.
And this is the powerful statement from the homeowner, George Wolchko, that kicked the whole thing off. You can really feel the frustration here, right? This wasn't just some petty neighborhood squabble. For him, this was about fundamental rights he was convinced were just being totally ignored.
So how in the world did it get to this point? Well, the whole conflict really boils down to 4 specific claims that Mr. Wolchko filed against his HOA, Victoria Manor. And each one, it peels back another layer of that super tricky relationship between a homeowner and the board that's supposed to be running the show. Yeah, these claims really cover the whole gamut. We're talking about a fight over getting official documents, a request for a special meeting that got shot down, a battle over a damaged wall, and even the basic setup of the HOA board itself. So we're going to break down every single one of these, and we'll start with that fight for the documents.
All right, first up, the fight for the documents. And this all started with what seems like a pretty simple request. Can I see the HOA's contract with its management company? You think that'd be easy, right? Well, as we're about to see, it was anything but. And this isn't just about being nice. This right is literally written into state law.
Okay, so this is the legal firepower behind the homeowner's first argument. It's an Arizona law that says an HOA has just 10 business days. That's it, to make its records reasonably available. And you got to pay attention to that phrase, reasonably available, because that's where this whole thing just goes off the rails. Just get a load of this timeline. The first request goes out on May 6th. But does he get the contract? Nope. It isn't actually delivered until the next February. We're talking nearly a whole year later, and it only happened because a legal case was filed. I mean, that delay is just, wow, it's staggering.
So you might be wondering, what was the HOA's excuse? Well, their argument was that they did comply. They offered him an in-person viewing at their office, which was a 45-minute drive away. But for Mr. Wolchko, who testified that he travels internationally for work, that just wasn't going to happen. And the big question is, why couldn't they just email the digital copies they obviously had on hand? And this, right here, is how a simple request balloons into a huge legal fight over the meaning of a single word, reasonable.
Okay, so now we're moving from a paper trail to a very real physical problem, a hole in a wall. This started as a simple repair job, but it quickly turned into a classic case of he said, she said. Just a lot of finger-pointing over who was really to blame.
So after an electrician hired by the HOA did some work on his building, Mr. Wolchko finds this gaping hole, just crudely stuffed with some foam. And you can practically hear the urgency in his email to the board. He's basically saying, hey, this is going to leak. I'm going to get mold inside my wall. It had just rained heavily, and he knew this thing was not even close to being watertight.
But the board's response? It was fast, and it was final. Not our problem. Their whole position was that their electrician just uncovered an issue that was already there, hidden behind an old electrical box. So in their eyes, they had absolutely zero responsibility to fix it. End of story.
But here is where the story takes a really interesting turn. The HOA itself went and got a second opinion from another contractor. And guess what? That contractor's report says that, yeah, the first company had in fact installed the wrong kind of box and completely failed to seal the hole. This was a direct contradiction to what the board had been saying all along.
All right, the last 2 claims kind of shift gears. We're moving away from physical repairs and into the nitty-gritty of how the HOA is run. We're talking about a homeowner's right to call a meeting and the actual structure of the board itself.
So getting totally frustrated with the back and forth over the wall, Mr. Wolchko does what the bylaws say you can do. He gathers enough signatures to force a special meeting to talk about it. But the HOA, they just flat out denied the request. Now, it turns out, the judge later found that while his heart was in the right place, the petition had a technical problem. He called it an emergency meeting, which is a power only the board has, and he forgot to list a location. A technicality, but a costly one.
And now for the final claim. This one gets to the very core of how this HOA is even supposed to operate. According to their own rulebook, their own bylaws, the board of directors must have at least 3 members. That's the rule. It's crystal clear. And yet, for months, the board had been running the whole show with just 2 people. See, a newly elected member resigned, and they just never filled the spot.
This was a direct violation of their own rules, which means just two people were making every single decision for the entire community.
So, after all the emails, all the arguments, all the testimony, how did it all shake out in the end? Let's get to the good part, the administrative law judge's final decision on these 4 big claims. Okay, so the judge's decision was a bit of a split, but it definitely leaned heavily in the homeowner's favor. Let's break it down. Document access. The judge found the HOA totally failed to meet that 10-day limit. That's a violation. The special meeting, that claim was denied because of that little technical flaw in the petition. Now, the wall repair? The judge agreed the HOA dropped the ball and failed in its duty. Violation. And the board vacancy? Yep, a clear violation of their own bylaws.
So when you add it all up, the final score was 3-1. The homeowners successfully proved that the HOA had failed on transparency, on maintenance, and on basic governance. I'd say that's a pretty decisive win, wouldn't you?
So, what's the big lesson here? What's the takeaway? Well, this whole saga really proves that homeowner rights are very real and they're protected by law. But, and this is a big but, it's also a huge reminder that the devil is always in the details. Just like we saw with that meeting request, one tiny procedural mistake can be enough to completely sink an otherwise solid complaint.
And that really leaves us with one final thought, doesn't it? This entire dispute from start to finish came down to what was written in state law and in the HOA's own rulebook. It really makes you stop and think, how well do you really know the rules that govern your own community? Something to chew on. Thanks for joining me on this one.